I've said before that I'm a First Amendment type of guy. I have long admired the American culture that values freedom of speech as a critical, non-negotiable and I think even more importantly, a virtually non-conditional component of a free society. And when Senator Wong talks about people being attacked, I should probably declare at this point that I'm a long-standing member of the Institute of Public Affairs and a former research fellow there, because what we've heard from the other side of this chamber and my good friend Senator Cameron, who just left, over and over again, is vilification of people merely by virtue of the institute at which they work. And there's a reason the Greens and the ALP hate the Institute of Public Affairs. It's because it's not part of your public sector mentality. It challenges the precepts that you put up, and it cannot be bowed by the fact that it's on the public sector drip the way you wish all civil society was. What we've just heard from Senator Wong, Mr Deputy President, and what we've heard constantly about this issue from those opposite, including the Greens, relies on a profound misunderstanding of what our society is. They seem to view that our rights, particularly our right to speech, our right to discuss, our right to participate in a democracy in a free flow of ideas, comes to us via a licence from politicians or judges. That somehow the laws in this place determine what we are allowed to and not allowed to say. Well, that is a profound misrepresentation of our constitutional and legal history. And it is only in recent times that there have been such limits on things like speech. But this is a profound fissure, Mr Deputy President, in what we view as the role of the state and what we view as the role of the government and its relationship with the citizens of this country. Senator Wong accused Senator Brandis of celebrating the rights of bigots. Mr Deputy President, what I will say is that I condemn the bigot, but I celebrate the rights of every citizen. And that is important, because a commitment to freedom of speech only really counts when it is tested. A commitment to freedom of speech only really counts when it comes to defending something you profoundly and viscerally disagree with. And that is where my commitment to free speech lies. It's not about public funding of artists, because I don't have to fund someone to support their right to say something. There's a profound difference between the allocation of taxpayers' resources to give to someone the right to do something, but at the same time, and comparing that to whether or not they are allowed to say something. And I will defend the right of someone to speak, but that does not entail and should not be confused with the fact that I should resource them to speak. We hear the constant complaint of those opposite in the last 48 hours about ethnic community leaders and multicultural community leaders and their views on this particular proposal. I said at the start that I was a First Amendment type of person, and I view the proposal put up by the government and Senator Brandis in the exposure draft as a compromise, because I accept that my views are not typical of all those in this place, or indeed all those in this country, in supporting a very strong and almost unlimited commitment to freedom of speech. The problem I have, Mr Acting Deputy President, is those opposites seem to see us as a nation of tribes, a nation where self-declared leaders of communities, these communities defined by race, those opposite are talking about communities and community leaders defined by race, that somehow they should have a special place in the consideration of legislation that any other Australian citizen should not. Well, I say, Mr Acting Deputy President, that every Australian's view has an equal standing before this place. Every Australian's view, no matter what community they declare themselves to be from, whether it be one or many, but not also because people may declare themselves to be leaders of communities. The elected bodies in this country are the elected representatives of the Australian people. We don't believe in a corporatist society or one where there are a series of tribes where somehow some people have more rights than others. The ALP and the Greens seek to define this as a debate about racism when it is not. It is a debate profoundly about speech, its limits and the role of governments, politicians and judges in limiting the rights of our fellow citizens to express ideas. How is it our role to empower certain people in Australia, in this case judges under the current law, to determine whether another's opinion is arrived at or expressed in good faith? Because that's a current provision in Section 18D. And what happened to Andrew Bolt was a court said that his opinion was not expressed in good faith. It didn't just ban the expression of that opinion, it banned its republication. It sort of had to declare an Orwellian moment that it never happened. the point being that for the gall of people in this place, it was once the centre and left of Australian politics that campaigned against censorship. Yet it is now the left of Australian politics that are its greatest advocates. Those opposite are confused between legality and licence. To make activities illegal, I'll rephrase that, Mr Acting Deputy President. To not make activities illegal is to not approve of them. The great problem with speech being banned is it denies people, community leaders, as Senator Wong pointed out, people like myself, people like yourself and others in this chamber, it denies us the opportunity to repudiate. Some speech should be repudiated, some speech should be humiliated, some speech should be ridiculed. But by banning it, it goes underground. And in this technological world, where we can't control the sources of news, that threat is even greater than when these laws were first passed just under 2 decades ago. Those opposite confuse this with defamation law, and it's an attempt to fudge the point, because defamation law often deals with issues and imputations of fact, not opinion. But this law can ban opinion. They talk about why are we concerned, because allegedly one journalist who they say is powerful had their opinion banned. I say the idea that a court said an article had to be stripped from a major newspaper's website and banned an expression of an opinion is something we should all be concerned about. And I remember the days when we would all be concerned about that. The most extreme left-wing activist lawyer in the United States for the ACLU would not tolerate this legislation. It shows how far the Labor Party and the Greens have moved from a respect for basic individual rights for this law to even be considered, to say nothing of the laws proposed by the former Attorney-General Nicola Roxon, which was going to expand the grounds for legal action from one citizen against another to an almost limitless number of grounds. Again, it confused the role of us here to, rather than set the boundaries and say what is illegal, to regulate and prescribe the expression of opinion and the expression of ideas. Now, Mr Acting Deputy President, I'm proud to say I know Andrew Bolt. I know him well. I wouldn't necessarily describe him as a friend, only because I don't know him that well. But the vilification to which he has been subject to by the professional left in this country over the last 2 years, the vilification, the use of the law to ban someone expressing opinions is unprecedented. It is unprecedented in Australia's past to ban people from expressing political opinions. I know Andrew, and he doesn't have a racist bone in his body. But those opposite who disagree seek to use the law to suppress his view. I tell you what was done. More harm was done to the views of those who oppose racism by taking this case and by the ruling by Justice Bromberg, which said a member of the victim group should be the standard by which it's measured. So there's no arbitrary test that any Australian can be certain of to know when their opinion will be legal and when their opinion will not be legal. More damage was done by the professional left activists and the legal censors that think it's their right to regulate speech in Australia, because while I have always opposed these laws, these were not on the public agenda until the laws you support here today, for the first time in my memory, meant that a court was going to ban the expression of opinion. We were going to censor newspapers, and we did, because republication of it was banned. Mr Acting Deputy President, I was invited a couple of years ago to give a speech to the Executive Council of Australian Jury on this point. And may I say I know Colin Rubinstein, I know Jeremy Jones, I know their work against racism is profound. I know they have done a lot of good work, but I respectfully disagree with them on these laws. And one of the reasons, and I can't recount all of that in the time available today, Mr Acting Deputy President, is where these laws exist, particularly in the old world of Europe, where there are speech codes, they are the places with, for example, armoured personnel carriers outside the new synagogue in Berlin that I saw just over a decade ago. They are the places with all the racial problems. It is the new world. It is the new world of Canada, which has recently repealed some of these laws, Australia and New Zealand and the United States, that has provided a home and sanctuary and refuge for people from all around the world. And in particular, the communities that have been oppressed in those countries of Europe have often found refuge in the country with the freest speech on earth, and that is the United States. I have faith in my fellow citizens that we will actually debate and come to the right resolution. Those opposites sadly do not, and I don't know where it went.